Good morning and welcome to the First District Court of Appeals. We have a number of students with us today. Special welcome to all of you. There are two cases on our docket this morning. I'll be calling the first one. After the first case is argued, we will take a brief recess and then I will call the second one. The first case this morning is C-24-0418, Hilty versus Donalyn McCarthy. Counsel, if you will please stand, state your name, the party you represent, and your readiness to proceed.
Thank you, Your Honor. Paige Richardson on behalf of appellants Grant Hilty and General Officer for this.
Thank you.
Your Honor, there's
Thank you. Counsel, you may come forward. Would you like to reserve time for rebuttal?
3 minutes, please, Your Honor.
All right, and you may start when you're ready.
Thank you. Good morning, Your Honors, and may it please the Court. There are two overarching legal issues presented to this Court today. The first is that of the correct standard of defamation law, and the second is the issue of derivative claims. The lower court in this case inappropriately applied the law on both, and for that reason, appellants are requesting that this Court remand for a new trial. The first issue is that of qualified privilege. The Supreme Court determined in Hahn that there are 5 factors in order for a party to qualified privilege to be applicable, and those are essential factors that must be analyzed in every case. Those are good faith, an interest to be upheld, a statement limited in scope to that interest, a proper occasion, and a proper manner to proper parties only. In this case, the lower court only looked at the second element, an interest to be upheld, and found that on the basis of relationship, the appellee was entitled to qualified privilege.
Counsel, which relationship counts? Is it the relationship between the subject of the communication and the person making the speech, or is it the relationship between the speaker and the audience?
It's the relationship between the alleged defamer and the listener. So in this case, the lower court determined that there was an employer-employee relationship, and that was inapplicable and did not exist in this case. And
Didn't the DME, didn't they technically employ the people who were the listeners? I mean, it was a contract situation. They paid for their services.
No, Your Honor. The DME, the listeners were customers of DME.
Okay. I meant that the customers paid DME, but they were still in some sort of a relationship where one of them paid the other, correct?
Correct, but in the cases that appellee cites in this case, in the briefing, the more common relationship that we see is more like that of a contractor-subcontractor, like in Smith versus Ameriflora. In this case, it's a business and its customers. For the common business interest to apply, the cases are tending to show more of a relationship where a common goal needs to be met. In this case, the customers were actually actively looking to release themselves from their DME contracts, so there wasn't a common business interest in those cases.
Counsel, you mentioned that the relationship is between the speaker and the listener. And my understanding was that the qualified privilege in the case of employer-employee relationships was to protect employers if they gave a reference or did some other thing related to that relationship. So can you clarify that for me?
Yes, there are cases where the employer-employee relationship is important for communications within the business, within DME, for example. Or
Would it protect DME if it gave a reference to a subsequent employer of
if
employee?
it's solicited. The case law specifically states that solicited references or information given may make the qualified privilege applicable. But in this case,
I'm sorry to interrupt, but that privilege is based on the relationship of the employer to its employee or former employee. not the listener.
I suppose that's correct, Your Honor, but it still would be, the relationship that you would be looking at is that of the former employer giving the reference to the potential new employer.
Okay, thank you.
And that goes to some of the interests that we see being upheld in the case law. In Hahn itself,
Counsel, can the contract, I mean, my understanding is that DME had existing contracts with these customers.
Correct.
Can the contract itself be the common interest? Don't both parties have a common interest in the carrying out of the contract?
well, again, in this case, Your Honor, almost all of the listeners to these statements were attempting to get out of their DME contracts. So there was no real common interest in pursuing the contract. The DME had a specific interest
You
in
mean, when you
in
say
retaining them.
get out of, do you mean breach or not renew?
Not renew, or pay out the contract and begin a new one. And the interests that we see being upheld commonly in the case law in Hahn was that of an insurance company and its policyholders that implies a legal duty. In A and B Able, which is another case that both parties cited to quite frequently, this is a case where there were public interest safety concerns, and they were reported specifically to public officials who could fix those safety concerns. In this case, we have a company who waited until their former employee was beyond his non-compete and was able to begin working, who unsolicited called up customers that he may begin prospecting to defame him. This is not the kind of interest that we see in all of these other cases.
If DME was concerned that its customers were about to be cheated because of their former employee, would that constitute a common interest?
If that information was solicited, it could be. However, in this case, there's evidence that shows that DME was not aware of any cheating on Mr. Hilty's behalf, and that these comments were not made in good faith.
What do we do with the jury verdicts? So the jury reached some different verdicts with respect to the different statements. How do we measure the jury's factual findings against the qualified privilege test?
That's a good question, Your Honor. I think there's a lot of confusion, and because this decision was made so early in the trial, there are a lot of kind of cascading errors from that, and one of them is the jury instructions. One thing that is important to know is that this decision comes after the prima facie case decision. So the question of qualified privilege, whether it's applicable, comes after the plaintiff has established their prima facie case. Many of the jury verdict interrogatories were based on that prima facie case inappropriately. And then on top of that, if the qualified privilege were properly analyzed, there is no evidence of good faith. There is no evidence specifically of good faith is the factor that is most important here. However, that was specifically not analyzed by the court, and this is notably an affirmative defense that the defendant needs to prove in order to avail itself of this defense.
Well, let me ask my question a little bit more specifically. So the Quigley statements, the jury found that those statements never happened. So would that outcome have been affected by a different qualified privilege ruling, or should we just set the qualified privilege decision aside with respect to the Quigley statements?
I think it would have been affected by a proper instruction on qualified privilege. Again, the prima facie elements should not be at issue where there's already a qualified privilege ruling. So the question of whether these statements happened at all should not be a question of fact for the jury, specifically because all of these defamation cases are saying that qualified privilege is only a question for the court where the circumstances are not in dispute, and that includes whether or not the statement was made. In this case, you have the appellee attempting to both avail itself of this defense, affirmative defense, where it has to prove that the statements were made in a certain manner, but also arguing that the statements were never made at all. There's a question of fact there.
But didn't the jury resolve that question of fact, at least with respect to the Quigley statements?
But they resolved it under this notion that the court already resolved certain things. I think that infected a lot of the decision-making going forward. And in addition, Your Honor, even if this court were to put the qualified privilege argument aside, there's the issue of the derivative claims that were not allowed to be considered by the jury. So the jury was told if you couldn't find actual malice on the defamation piece, then you stop completely. You don't consider the breach of contract on the disparagement, and you don't consider the tortious interference claim. But there were some statements that didn't rise to the level of defamation that should have been considered under the disparagement, the non-disparagement provision in the contract, and also to consider whether or not those were interfering with a business relationship or whether they applied under the tortious interference claim.
That brings up a question for me. Specifically for the breach of contract, that's a disparagement issue.
Correct.
Can you articulate for me how, first of all, question number one, could the breach of contract claim have been litigated even without, if there was no defamation claim?
Yes, Your Honor.
Okay. And then how are the two, as far as, if there was no defamation claim, would all of these statements be allowed to be considered?
So, no, Your Honor. The Supreme Court has determined that there are certain protections guaranteed by the First Amendment, and that you can't get around that with creative pleading, essentially by pleading a breach of contract instead of a defamation claim. Appellants are conceding that in this case. We know that there are some derivative, there is a derivative nature here. The question is whether the statements like the vulgar comment that Mr. George made, which was not defamatory, but was disparaging and impugning Mr. Hilty, whether that should have come in separately under the breach of contract claim, whether or not, regardless of the privilege issue.
What's the proper analysis here? Do we go line by line, statement by statement, determine whether it falls in the defamation category or the breach of contract category, and whose job is that? Is it a trial court function, bar function?
I think that's a trial court function, Your Honor, and the trial court did that. The trial court in its order on the motion for reconsideration prior to trial did go through each of the statements presented here and determined whether or not they were defamatory per se as a matter of law, which was a correct analysis. And we're not appealing those issues. So I think that analysis remains. Those statements that were found to be defamatory per se fall under the defamation category, and the other statements that either were excluded from the jury, from the jury's purview, or that were found as a matter of law not to be defamatory, those would fall under one of the other two.
All right, and counsel, you're out of time. Thank you very much.
Good morning, Your Honors. Mike Caligaris again for DME. After 7 days of trial, the jury unquestionably got it right on defamation law.
Well, let me stop you, though. Doesn't that start with the trial court's determination about privilege?
Exactly. So, Your Honor, you're spot on. So the qualified privilege argument, which DME maintained below prior to trial, moved for reconsideration on and asked for a ruling prior to commencement of trial, was ultimately ruled upon by Judge McBride about 3 days into trial, after supplemental briefing was requested. Judge McBride had a lot of integrity in this trial. He was a visiting judge. We don't envy the position he was in, which was trying to get up to speed in a short amount of time to try this case. And as time went on, he started to realize the way in which the court had to decide issues of law in this trial. And we, as DME, have always maintained that those issues of law should have been decided prior to commencement of trial.
What was the common business interest between DME and the customers?
Thank you, Judge Kinsley. So the DME common interest here is all 5 of these alleged listeners of defamation were DME customers under multi-year contracts, all 5. And in some cases, they had multiple contracts. And they were set to expire well after the time period of defamation. And so the relationship there is that under Hahn, we have the generic, or the seminal standard, should I say, for qualified privilege, which is the 5 elements. There's a later in time with George Alice, as cited in our brief, and the case law in the last 10 years, where common business interest is maybe a way to categorize a qualified privilege. And entities are not related other than the common business interest and do not have the same employer between publisher and listener. And then in light of the Hahn factors, it's made in good faith and for purposes of that interest. All 5 of the communications on the face of the complaint, the way it is pled, and the way that it was presented to the jury at trial and upon their deliberations, were defamation per se statements on their face that were, if you read them, they were made in the context of DME talking DME business with DME's own customers.
Okay. I'd like for you to help me out here because I'm viewing it in a slightly different manner.
Sure.
I see it as a company who wants to retain its business with these various customers. What's a good word for it? Trashing or disparaging a competitor. So how, and it to me, that's different than the various cases that I read that talked about a common business interest. This is a company talking about a competitor, not a company talking to its customer about a mutual interest in a different thing, like the case with Toyota. So can you, I feel like this case is distinguishable from every other case I read. Do you have any case law or any authority that's directly on point where it's a company that is talking about a competitor?
I don't believe we cited one where it was a competitor context, but what I would say is in every single situation where this statement was made, allegedly, these were not, as presented by appellants, DME going around with a motive to defame Appellant Hilty. These were situations like Enos Britton, which is one of the 5 prospective customers by appellant or DME's own customer, where the representative of Enos Britton was calling upon DME to renegotiate their contract because they were being solicited by a competitor. And though we did not know, DME did not know that at the time, when those statements were allegedly made about Mr. Hilty were never presented at trial because they never called anyone from Enos Britton But Appellant Hilty did testify on the stand as to those communications with Enos Britton. And what the evidence showed was that the Enos Britton representative who allegedly heard this defamation was receiving communications from Grant Hilty for several months in which he was coaching her on which to say back to DME to get a better contract. That was in the behind the scenes. And then when the statements were allegedly made, it was calling upon a DME salesman to come to their office to discuss and negotiate the contract. And because they were upset with the contract. They were upset with the contract put in place when Grant Hilty was a DME employee. So they were disputing their own contractual terms negotiated with Grant Hilty at his time of his employment with DME, with a new DME representative. And DME representative was discussing with them how they can retain their business under this multi-year contract and not be solicited away by modern office methods.
How do we ensure that the privilege doesn't swallow the tort? I think that's what Judge Bach is getting at, right? So how do we ensure that a cause of action for defamation does remain when there is business competition and one company is disparaging another?
And that's a great question. And I think, in the competitive sales industry, this is probably something that is not unusual. But what I would say is that is why actual malice exists and why actual malice standard is required to be, the burden of proof for the appellants below. The qualified privilege, I understand the question being that how do we avoid qualified privilege being a full excuse, but that is what a privilege is qualified. It's not absolute privilege. And so upon evidence of a non-good faith purpose or actual malice and reckless disregard, that is how you can establish a defamation per se case. And again, the defamation per se is about the statement on its face, not totality of circumstances, things like that. And frankly, the evidence presented at trial to prove the defamation per se statement on its face was lacking. And before
Were
we even got
these
to that
jury
point.
questions? So I think there's a procedural, in addition to perhaps factual or legal disputes between the two sides, I think there's also a procedural dispute here with one side believing this was a jury question and your side believing this was a legal question. Were there jury questions to be tried as to whether these statements by DME were made in good or bad faith?
And that was for the actual malice jury interrogatory, correct, yes.
So do you then believe that the actual malice standard and the bad faith standard in qualified privilege are redundant of one another?
No, I would not say that. I would say that the qualified privilege was already determined as a matter of law, so they were instructed on that because Judge McBride decided that issue, which is an issue for the court. When they got to the actual malice instruction, they were reminded that the qualified privilege affirmative defense, which was the somewhat confusing part about this trial, is that we had to present that in opening as our affirmative defense we're going to prove with, preponderance of the evidence. Then it was ultimately decided as an issue of law. At the time of jury instruction, the actual malice standard and the way that Judge McBride instructed them, which spans 2 to 3 pages, explains to them that the qualified privilege exists. However, it only exists if the statement was made without actual malice. Actual malice, what does that mean? And there's a full explanation. Ultimately, the jury, out of 5 prospective customers or DME's own customers, the statements made, only one made it past the qualified privilege for determination on actual malice and whether or not evidence was presented on actual malice. And that was for maintenance methods, Angela Connor's testimony. Angela Connors testified at trial. The statements were not determinative of her decision to stay under a contract.
Isn't that a bit of, or potentially a procedural problem in that perhaps, I think your opponent is contesting whether the trial court had in front of it at the time it made the qualified privilege determination, whether it had sufficient facts to determine the good faith, bad faith question. Mm-hmm. And then the jury only resolved that question potentially, at most, on one party. So what do we do now, looking back at this record? Is there enough to justify the trial court's legal determination on the good faith, bad faith question at the qualified privilege stage?
That's a great question. I think either way you look at it, if it's an issue of fact, by the time that Judge McBride had issued that determination of law, it was day 3 trial, supplemental briefing. We already had Grant Hilty's testimony and Angela Connors. Grant Hilty testified under oath that, yes, all 5 of these were DME's customers under DME contracts. We painstakingly went through the terms of those contracts. Grant Hilty also testified that, yes, he was soliciting these 5 prospective businesses in modern office methods. And what the evidence ultimately showed was that they did solicit 3 of the 5 away from DME to a tune of 6 figures. And so the common business interest, I think, on the evidence was there, but under the law in Ohio, the Supreme Court has made clear that that's a determination of law that should have been made prior to trial when there's no dispute of fact.
Please silence your phones.
Your Honor, I believe this is.
All right.
I apologize. I
No
thought-
problem, and if you need to take a minute, that's okay.
All right, I appreciate it. Thank you.
No
I'm
problem.
very sorry for that.
No problem, it happens.
The Supreme Court has held since the 1950s that the issue of qualified privilege and whether or not a statement is defamatory per se on its face is an issue of law for the court. And that is why DME maintained that, moved for reconsideration after summary judgment was denied, because we told the court, we don't have the ability to try this case until this is rendered in the statements as an issue of law, and what statements are we going forward on, and which ones where the qualified privilege applies.
Was there no dispute about the statements,
In terms of
whether they were
denied
said or not?
Yes, there was dispute, and
And the qualified privilege in terms of being as a matter of law only applies when there's no dispute, is that right?
I disagree with that. If that were the case, then you would not be able to ever assert an affirmative defense if you denied the allegations of a lawsuit. The
Well,
qualified.
you could assert it, it's just a matter of whether it was proven, whether the statements were made or not.
That's correct. I think in terms of an evidentiary review, at the trial court level, when we were presenting that evidence of the statements, only 3 of the 5 prospective customers testified to establish that a statement was allegedly made.
So there was a dispute with respect to whether the statements were made.
Yes, I think that as to some of the statements, Steve Sexton for DME did testify that, yes, he probably did make the statement. He doesn't recall because, it was a phone call or things like that. There were some concessions that statements were made, just not the way in which these statements were listed as defamatory per se and verbatim made.
Can I turn to the breach of contract claim?
Correct, yeah.
And that arises from the settlement agreement that was entered into between the parties, is that right?
Yes, and
And that settlement agreement in paragraph 11 says that your client will not in any manner disparage or impugn Mr. Hilty's reputation. Is that correct?
it was mutual, correct.
Right, but with respect to your client's obligations, that was one of your client's obligations, is that right?
That is correct.
And there's an allegation that your client made a comment that Mr. Hilty was a piece of shit. Is that right?
That was one of the allegations that was ultimately thrown out, yes.
And and I apologize for going to cross-exam mode. This is,
That's okay.
I'm trying to get used
No, I
to
understand.
not doing that. But with that, if that statement were in fact said, wouldn't that violate this paragraph 11 of the agreement?
Well, there's 2 responses to that. First being that the way the complaint is pled and the way that it was presented at trial, paragraph 30, the breach of the settlement agreement was based on the above-described communications with Mr. Quigley, Mr. Casey, Ms. Moran, Mr. Kilgore, Ms. Begley, and Ms. Connors. Those are the 5 prospective customers. The allegations of the complaint are all the defamatory alleged statements. So I think as to the vulgar statement that was made, that was first pled on the complaint and through trial as defamatory. Obviously, it was opinion, and so that was thrown out by Judge McBride later. But ultimately, the derivative nature of which this disparagement breach of contract claim relates to the defamation per se is how it was presented, how it was pled, and ultimately, jury interrogatory number 1 shows that the jury didn't believe that President Jim George of DME said that to Mr. Quigley.
Well, doesn't that interrogatory, though, it's confined to DME's agent telling Quigley that Hilty was a liar. It doesn't reference the piece of shit comment.
By that point, it was already out as opinion, yes. But I would say that ultimately, I don't believe that the jury found evidence that Mr. Quigley was credible in any of his testimony.
But if the jury had found that that statement was in fact made, that would be a violation of the contract.
I think under disparagement law, it's a broad scope, and it's
Well, let me-
possibly true.
And
but-
I'm sorry, let me ask a better question. Is there any context in which a statement like that would not disparage or impugn Mr. Hilty's reputation?
Is there any context in which the statement such as that would not impugn his character? I don't believe so. I think that is an opinion-based but vulgar statement about someone's character based on their own evaluation of them.
And the contract said your client ought not do that.
Correct, and there was evidence at trial for purposes of DME's affirmative defense of truth, where similar type conduct was presented on the other side.
I'm like, truth of him being a piece of,
No, not in that regard, but truth of, I guess, the alleged statements being made as being supported by truth, I guess as a qualified opinion, you could take the totality of the evidence presented towards our truth defense to understand why, if Mr. George had made that statement, that's why he made that statement.
is there, well, no, thank you.
Are there any further questions? Just to wrap up before my time, I would say that the Supreme Court of Ohio's precedent makes clear that these are derivative claims, both the breach of contract and the tortious interference that are pled on the face, such as so. Modern Office Methods' own corporate rep and principal testified that he's not making a claim for his business on tortious interference outside of the defamatory statements of Grant Hilty. And that was what the jury was asked to do. Judge McBride did a great job and had a lot of integrity in making sure he got the law right. The jury was very patient and very, very careful in applying the law, and ultimately it led to the right result. So thank you for your time.
Thank you.
Thank you, Your Honors. I'd like to start by pointing out that Mr. Caligaris said something very important. This is not an absolute privilege. The appellees have the burden to prove their affirmative defense of qualified privilege. Even as this oral argument was going on, they cannot do that. They cannot admit that the statements were even made.
Is the jury's finding on, apologize, but the Modern Methods, the company I'm speaking of.
Yeah.
Is the jury's finding on that particular statement that there was no actual malice, does that carry over to the good faith, bad faith question on qualified privilege?
No, Your Honor, and that is specifically addressed in both Hahn and in A and B Able. The Supreme Court specifically laid out that those are two different good faith arguments. The good faith that comes in under the qualified privilege defense does not include motive. Under the actual malice standard, it's a completely different question of good faith, bad faith, and it includes motive, and that's specifically laid out by the Supreme Court in those two cases. I also want to talk about the evidence that was submitted at trial. There were certain orders that were made by the court excluding certain evidence. Evidence of 2 of the 5 customers in the alleged statements were not presented to the jury, not because a plaintiff was conceding them, but because there was an order regarding hearsay that there could not be testimony to that effect to the jury.
Wouldn't the statements of the customers who didn't testify, wouldn't those be out not just on hearsay, but also because Mr. Hilty did not have firsthand knowledge?
Well, in this case, Your Honor, the statements would not be hearsay definitionally.
I don't want to talk about hearsay.
Oh, okay.
I want to talk about whether it was firsthand knowledge under 601 or 602, I can't remember which.
So what happened, Your Honor, is the statement was made to these customers. The customers immediately or shortly thereafter called Mr. Hilty to report this conduct. That is something that many defamation cases, you can see it in Bowdoin and Knowles, That's the kind of testimony that is typically allowed in defamation cases because of the constraints of those kinds of claims.
Mr. Hilty didn't hear those statements.
He didn't. He heard them from the listener. So there is, not to go back to hearsay, but there is a double layer of hearsay. But the hearsay argument was not, the hearsay application was not appropriate in that case.
But the personal knowledge question is going back to Judge Bach's question. Mr. Hilty testified as to what someone told him they were told.
Correct.
That strikes me as problematic.
I understand the argument. I think that in defamation cases, this is something that does come up because the statements do have to come in to evidence, or else no one would be able to.
But don't they come in through the person that heard those statements?
Occasionally, that would be the ideal way. Sometimes there are issues with that, of course, as trial attorneys know. There's
Well, counsel, what
witness issues.
circumstances would allow evidence to come in that someone says they heard from someone else?
This is exactly what happened in Bowdoin, which is a Southern District case applying Ohio defamation law. And this is also similar to what happened in Knowles, which was, I can't remember, I think a 10th District case. This is something that happens in defamation cases where, because a plaintiff has to be able to testify as to the effect to his reputation about statements that he may not have heard firsthand. That's typical in defamation cases.
In Knowles, though, the question was whether the listener of those statements could testify to those statements. It wasn't whether the listener told somebody and the somebody that the listener told was allowed to testify to what they were told they were told.
I think, if I'm remembering correctly, Your Honor, I don't have it in front of me, but I think there was also a question of whether I think it was the president or the dean of the university, the one being defamed, if he could testify as to what that listener heard as well.
And Counsel, you're out of time if you'd like to wrap up.
Thank you. Can I have a minute to wrap up?
Yes, you may.
Thank you. I do very quickly want to talk about the derivative claims. In this case, appellant is conceding that there is a derivative claim nature in this case. However, the appellee is shackling plaintiffs to a defamation standard that may not even apply. As you heard, some were thrown out because they did not meet the defamation per se standard. So again, appellant would ask that this court remand for a new trial. Thank you.
Thank you. Thank you both for your advocacy this morning. We will take the matter under submission and issue a timely decision. Enjoy the rest of your day, and the court will stand in brief recess.
All rise. The Court of Appeals, First Appellate District of Ohio is now in recess.